So as a strategic matter then, does it behoove counsel to raise as many issues in the brief as they think there are possible assignments of error, to give the court perhaps an opportunity? Or does the court actually respond negatively to having a brief that has too many issues in it? Justice Millette? What?
Personally, I think I respond negatively to it. I think if you've got some really good points, you should focus on the really good points rather than just sort of the shotgun approach and saying, I hope something sticks against the wall. Having said that, it is almost asking us to read our minds to say, well, how do I know what's going to be really important? I think if you really understand the law, if you've studied the law of your particular case and you know the facts of your case real well, you'll be able to divine, actually that's a poor choice of words, you'll be able to understand what are the real issues that need to be addressed.
Well, let's now turn to the issue of how you start engaging with a case. So let me return to the question that I posed earlier.
Last time? Okay.
And then Chief Justice Kinzer, maybe I'll ask you to comment as well. So you get the stack of papers, the briefs and the record on your desk. How do you first dig in?
Interestingly, we have most of the cases that we deal with have already had a writ memo prepared by one of our chief staff attorneys or our own law clerks. And that writ memo has gone to the writ panel, the three-justice panel, and the panel has decided that they're going to grant the writ on that. So I usually start there because it's sort of an overview of the case, and it's usually about 10, 12 pages, so it gets you a good overview of the case fairly quickly. I then look at the appellant's brief, and as I'm reading the appellant's brief, I will go through the record. Now, almost always I'll read the complaint, one of the first things I do, because almost always in every case, it's a civil case, the complaint is going to have some impact on the outcome of the case. But I do want to understand what the facts of the case are and the way the case is set up. And after I've read the appellant's brief and perused the record, then I'll read the appellee's brief and look at the record as part of that.
Chief Justice, the same approach or?
Not exactly.
No? What's your approach?
I read the appellant's brief, I read the appellee's brief, I read the reply brief so that I fully understand what at least the parties think the issues are.
In that order?
In that order, yes. And then I'll go to the record. Now, I'm not saying that, I never go to the record in the process of that. Maybe there's a letter opinion from the trial court, and after having read the appellant's brief, I really want to see what the trial court says, so I may stop and, go to the. So it depends on the case and what the issues are. The writ memo that Justice Millette referred to, I don't look at this point. I mean, I should say never, but that's a condensed version of the issues that were presented at the petition stage. And I only look at that if I've read all the briefs and I feel like they didn't tell me what this case is about. Maybe there's something in the written memo that will help me. So I very seldom look at those once a case has been granted an appeal by the court. Don't say never, but it's certainly the last thing I do. And after I've done all of that, I would then turn to research that my law clerks have given me, or a bench memo that I might have asked them to do, or do my own research. But
anybody start with the appellee's brief? No? Everybody starts at the beginning and works their way through? Yeah. So at what point then, as you're reading, are you typically persuaded, or at least are you starting to form your thinking around the case? So maybe Justice Powell, I could ask you to start on this. So you start with the appellant's brief? And at what point in the brief do you start to think, okay, I know what this case is about, I'm starting to get this? Is it by the statement of facts?
Is it that I know what the case is about, or I know what the answer is? Which question?
Well, I'll leave it to you to answer that. Let's tend more towards the latter, actually. You're starting to form your view on the case.
It's an evolving process, actually. If I have a well-written appellant's brief, unfortunately, at the end of it, I've decided, yeah, you win. And I pick up the appellee's brief and I read that, and at the end of that I thought, oh no, they no longer win, the appellee wins. And then I get to the reply brief, and so it is an evolving process where I am considering the arguments that are made and very persuasive arguments from the two parties. Rarely after I've read everything do I have the answer. I usually wait until oral argument. Sometimes I'll talk with colleagues about it. Certainly the opinion conference has an impact on what the final decision, as far as I'm concerned, will be. And it may even go as far as the draft opinion that comes out before I can finally say I'm comfortable with this position. Usually it's very late in the process for me before I finally settle on a position.
Justice Goodwyn, let me ask you to address that as well, so that your thought process as you work through the case. So Justice Powell has talked about it being an evolving process. I'm sure that's the same for you as well. But do your thoughts continue to evolve through oral argument, through conference, or do you go into oral argument or into conference with a pretty clear sense of what you think?
I would say typically my process works exactly like Judge Powell's process, but in reality, what I've realized is depending on the subject area of the case, I might have more of an intuitive feel as to how it ought to go. If I know the body of law in a particular area and somebody's asking me to do something that seems completely contrary to the last 4 cases we decided, it's like, they've got a boulder they're pushing up a hill here. And I'm not saying I made up my mind one way or the other. I'm just saying that, all the alarms are going off that, if I've read the appellant's brief, I'm like,
Use a term of art, yes.
Yeah, exactly. That was a technical term.
Yes.
So that happens, and I find it happens the more background I have in the information in the particular subject area of the case. But even with that being said, I'm going to read everything, and my mind is completely open. And one of the things that kind of amazed me when I got to this court, because I read everything, and I think everybody's process is probably somewhat the same. You read the briefs, then I'm going to look at the research, typically a bench memo or something like that. And then a lot of times I'll have little questions. As I'm going through the briefs, I make notes like, why did they say that? Well, that don't make any sense. And then I go back and kind of answer my own questions to all these things that were left hanging out there. And then I pick up a dictaphone and I do something, I call it my bottom line, that my law clerks go. I just pick up the dictaphone and says, look, you know what the real deal on this case is? And then I just kind of dictate to myself how I think they're trying to tell me and characterize the case in the way that I believe it ought to be characterized given the facts and given what happened at trial and what the important concepts are that have to be dealt with and the questions that have to be dealt with. And that's what I'm going to take into the opinion conference with me as my colleagues talk. That's kind of like my touchstone for how I'm going to analyze things. And typically I try to come up with an answer at the end. But all of that being said, I was shocked to know how many times I have all of that and I get to oral argument and somebody says something like, I never thought of it that way. Wow, maybe I mischaracterized what the real issue is, and then you're all ears to try to fill in the blanks. So I think it is an evolving process, and I think we've all honestly been doing this long enough that you never say never. You're going to read everything and you want to understand the issues, and you're keeping an open enough mind so that when you hear something that doesn't fit into the concept or the construct you've created, you're like, wait a minute, I hadn't thought of that. Where does that fit? Does that make a difference? Whoa. And you see people at oral argument start sitting up on the edge of their chair like, oh, and sometimes you see people's eyes get really big as they have a revelation during the process.
So now I have to ask what you do with that recording you make. Do you listen to it yourself at conference?
No, I have my secretary type it,
okay.
And it goes into a document I call the bottom line. So I've got, all the cases and everything, and then I've got Bernard's bottom line.
I call it Cynthia's stream of consciousness. Because I do the same thing. It's my stream of consciousness after I've gone through everything, and I dictate what I'm thinking at that point. It goes into my notebook for court week. My secretary types it up as well. And sometimes what I eventually do is contrary to what those notes say, but it helps me prepare for court week after I've read so many briefs.
So it sounds like, Chief Justice, that you likewise have been maybe persuaded at argument to think about something you hadn't thought about before. Are you persuaded ever by the writing, by the force of the argument in the brief? So you look at the issues and you think, perhaps approaching it with the same experience that Justice Goodwyn said, well, I know the law in this area, that seems like an uphill climb, and then you read the brief and the language, the strength of the argument maybe gets you to see it a different way?
Well, certainly the better the writing, the better the analysis in the brief, the more it helps me understand. And if you're helping me understand, then you're more likely to persuade me to that particular viewpoint. but it's not a moot court contest. So I'm not judging which brief or which oral argument is best. It doesn't mean that the person who wrote the best brief or presented the best oral argument is always going to win. That's frequently not the case. But it just, the better the oral argument, the better the brief, the more it helps me in coming to a decision and understanding the case and why I think a certain way.
Are amicus briefs ever helpful to you? Or how often are they helpful if they are?
Probably half the time. An amicus brief is good if it approaches it from a different viewpoint than that expressed by the appellant or appellee. But if the amicus brief is just repeating the arguments that have already been made by one side or the other, then it's not worth my time reading it. I mean, I read it, but at the end of the day, it hasn't helped me because it hasn't told me anything new. It needs to tell me something new that I haven't thought about or that the other parties haven't addressed.
So Justice Lemons, what's your view of amicus briefs?
You know, the word amicus means friend, and sometimes the party or the organization filing the brief is in fact your friend, and sometimes they're far more interested in their own underlying policy issues to be your friend. So sometimes amicus briefs really are not helpful to the specific issues that are before the court. They may very well be policy driven, whereas we're probably going to be driven by the narrow answering of individual assignments of error. Now, having said that, in the famous Grutter case in Michigan, when it got to the United States Supreme Court, it was an amicus brief that actually resolved the case. It was filed by the Joint Chiefs of Staff. And if you read the majority opinion in Grutter, you'll see that the amicus brief by the Joint Chiefs of Staff made it clear that they thought that nothing less than the security of the United States was necessary. It was necessary to have diversity in the officer corps in order to have chains of command that were going to be followed. And as a consequence, the amicus brief made the point that if you don't have diversity in professional education, you're not likely to have diversity in the United States military. If you read the opinion of the United States Supreme Court, you'll find an amicus brief made the difference. Now, sometimes that's the case here, but more often than not, it's not the case.
So it sounds like, along with what Chief Justice was saying, that in those cases where you're not simply engaging in error correction, but are helping to interpret the law, perhaps a perspective that you haven't heard from before that highlights the policy issues might be an important. Justice Millette, do you talk to me about your process again in going through the case? You talked a little bit about how you approach the case. At what point are you persuaded, or do you start to form your view? Do you form it as you're reading the briefs? Do you wait for oral argument?
I think I form it as I'm reading the briefs. Certainly, as I understand the case more and more, and I understand the parties' positions more and more, I start to feel more comfortable that I agree or disagree with whatever the appellant is arguing or whatever the appellee is arguing. But I don't make a final decision, I'm convinced, until I've heard everything. Certainly, even the oral argument. I've changed my mind a number of times after hearing the oral argument, and I think it's just the nature of the decision-making process.
So part of what is part of the record in each case is the opinion coming up from the lower court. Justice Lemons, let me ask you, do you assess the case in any particular way or in any particular posture depending on where the case is coming from?
I often avoid discovering which judge it came from in order to avoid that being an issue. It shouldn't be. The judge who decided the case below ought to be just a neutral factor. And we ought to decide the case based on what's been presented to us, irrespective of who made the call at the trial court.
Could it be helpful to you in some instances? So related to our earlier discussion about everyone brings some background, some life experience to the case. So if you knew, for example, that the judge below had extensive experience in law enforcement or other sorts of areas that might actually be helpful to framing the case, would that be information that would be interesting to you?
Well, it's interesting you'd frame it that way because it raises another issue that we have in appellate review. On matters of sufficiency of the evidence, for example, I mean, our standard is plainly wrong or without evidence to support it. Now, does that mean that we would have made the same decision? No, it does not. What it means is, does the trial judge have before him or her sufficient evidence to support their decision? And I know I speak for my colleagues when I say that we have cases that come before us that we affirm that we would not have decided the same way in the court below. And I suspect that is a deference that's built into the system that we respect.
Does that deference change depending on the experience of the judge below or the characteristics of the judge below?
I think it is without regard to the experience of the judge below. I mean, if we look at a record and the record is sufficient to support the judgment is affirmed. And I don't think it necessarily is influenced by the fact that perhaps a judge was a prosecutor one time, or a judge was a public defender, or a judge was a plaintiff's lawyer, or a civil insurance defense lawyer. I just don't think that has much influence at all once it gets to us. But I do think that the trial court has a lot of leeway once it gets to us, no matter what.
Justice Goodwyn, do you pay attention to who the judge was below? Or?
No, I don't. I guess it goes back to my analogy about balls and strikes. I mean, if you Rod Carew, sometimes he was out at first, you know? I mean, so I'm just gonna look at the facts of the particular case and decide whether or not a mistake was made. It really doesn't matter at all who made the call. And it goes back to, quite honestly, how narrowly we decide things. I mean, I'm just looking at the assignment of error, I'm looking at the record, and I'm trying to see, given the law, whether or not a mistake was made.
So, all right, so we've had oral argument, and now we start the sort of conference and decision process. So I was wondering if we could talk a little bit about the decision-making process at that point. And maybe, Chief Justice, I could start with you. Do you use your clerks to try to sort of think through some of the ideas? Do you exchange memos or emails with your colleagues? Do you really kind of try to thrash it out at conference to reach a decision? How does the eventual opinion result from the process?
I think it depends on the case. Mm-hmm. If it's a fairly straightforward, simple case with perhaps just one or two issues, then it probably has been thrashed out, at least for me, before I ever get to oral argument. That doesn't mean that in those cases that my mind might not be changed in some way. But for me, when the opinion writing comes, you know, it's sitting down and writing it based on what I've heard from my colleagues at opinion conference and what my own thoughts are about it. Writing a majority opinion is an interesting experience because for me personally, while I've got to reflect the views of at least 3 other people, if my name's on it, I'm not going to have anything in there that I don't agree with. And so there have been times when I've written an opinion that really was not the opinion that people probably thought I was going to write because I got into it and realized this doesn't work, it doesn't write. And so I may send them a memo when I circulate it that explains why I've gone down a different path and hope that at least 3 other people will agree with me after they've had time to think about it. But in terms of the interchange and exchange of information and memos between our colleagues, again, I think it depends on the case. If I'm troubled about an issue and want to talk with a person, one of my colleagues, perhaps voice something at an opinion conference, and I want to explore that with them a little bit, I may call them, I may email them, or whatever. And then sometimes after an opinion is circulated, some of us may circulate a memo to maybe first to the author, or just call them, and then it might go to the whole court. It just depends.
So do you ever actually regroup? So if you have an opinion that didn't write, and so now you think, well, we have to change direction here a little bit to make this work. Will you have a second conference to talk about the issues?
Oh, we do. I mean, we have a conference in the afternoon after we've heard oral arguments. And then 5 weeks later, after we've had writ panels, we have what we call an opinion conference. And by then we have circulated those opinions to each other that we've written from the last court week. And we talk about them and get each other's comments. I'll never forget the first opinion conference that I attended. That evening there was a dinner, and I saw one of my colleagues who was a senior justice at the time, and he said, well, did you have your baptism today? And I said, yes, I did indeed. So it's very interesting, the comments that you get from your colleagues from, you need a comma here or you don't need a comma there, to very substantive suggestions about the opinion and changes that should be made. So that's the primary regrouping time. And then after that, we would circulate these revised opinions to each other again. And then we actually talk about them again, via email and on Monday of court week.
So when you are surprised by a more substantive suggestion, where does that come from? Is it because you perhaps didn't have the sense you thought you had about your colleague's position on a case before that time? Or there's been a change of thinking about the case? What do you think causes that surprise when a comment comes in that you weren't expecting?
Oh, I don't think most of the comments that come in are probably things that I have been expecting. But sometimes they may have a suggestion, a way to improve upon how I've presented a particular issue. We welcome all of them. But I don't know that there are too many comments that come that I didn't have some sense of, perhaps from the discussions at opinion conference in the afternoons after we've heard the cases.
Justice Lemons, what about you? Do you feel as if by the time of the conference you know what your colleagues are thinking about a case?
The initial conference,
Yeah.
you're talking about,
Justice
right?
Goodwyn is already
Yes.
nodding his head, but do you think, by
Well,
the conference you know, or not, or you get surprised?
Most times the answer is yes. It's the ones where the answer is no that are most surprising, because from time to time you go around the table and you make your views known, and every once in a while you really are surprised by how a vote comes out. But underlying all of this is one principle that needs to be stated. The opinions of the court are the court's opinions. Now, an author has a challenge of writing an opinion that attracts a majority in order to have a court's opinion. And so even if we were not inclined to listen to other people, you have to be listening to other people in order to command a majority and to have an opinion that is the court's opinion. And the Chief Justice, I think, is absolutely right. There's nothing that more keenly focuses the mind than writing. And many times you go from a table where what you've been doing is talking about it, and then you go back to your chambers and you actually have to write it, and it's a different question altogether.
So what do you do when an opinion doesn't write?
Oh my goodness, I do exactly what all of my colleagues do. When I came on the court, and Chief Justice Kinzer now was on the court at the same time, there was a tradition of not talking amongst the justices until you got to this opinion conference that she referred to as the baptism. And I suspect the reason why it was referred to it that way is because you had no idea what your colleagues were going to say. Today, we don't operate that way. We feel free to pick up the telephone and call each other, send each other emails, and discuss things. So when we actually get to that second opinion conference, the first one is on the day of the argument, the second one was when a draft is out there, most of us have heard from our colleagues, and we have a pretty good idea where the pressure points are. It's a much better way to produce a majority, or for that matter, a dissent.
Oh, absolutely. At this point, I've been on the court longer than anyone else here, which says something about my age, I guess. But I remember very well being told when I started on the court that you talk about the cases after you've heard oral argument in the morning, and you haven't talked to anybody about them before that. And once the opinion comes from your colleagues, that what they've written, you don't offer any comment back to them about it until you come together again that fifth week I was talking about. And so you were often blindsided by very substantive questions, comments, and you're just like, you're struggling to remember what your thought process for why you wrote it that way, whereas if it comes earlier, you've had a chance to think about it. And I remember so well the first time that I dared to send a comment to one of my colleagues before the opinion conference. And I had found a case that I thought would really help the opinion, and I wanted to offer it to him. And so I sent him an email, and did not know whether I would incur his wrath or not. But he put it in the opinion. At opinion conference said, you know, Cynthia offered this to me, and I think it was a good suggestion, and I've incorporated it. And you could have knocked me over because I didn't know what the reaction was going to be. But it was good, and I think slowly that has changed, and I think it's a good change.
More collaborative
Yes.
process because of necessity. It's the opinion of the court, and so even though it's authored in most cases by a particular justice. Justice Goodwyn, you sort of nodded when we talked about maybe once in a while being surprised.
Being surprised, I guess I was thinking, first of all, it's important to understand that when we have an opinion conference after oral argument, every person on the court speaks to that case. So you know how everybody at that point in time anyway thinks the court ought to be resolved, how the case ought to be resolved. And if you're the person writing the opinion, you're writing the opinion, you've told them what you plan to put in it, and that's what should come back. So when the first time we go around the table, a lot of times I don't know what people are going to say. You might have a sense, but you don't. And sometimes people have provocative, not the right word, but you know, the ball bounced at an odd angle. I mean, you know, from what I thought the way it was going to bounce when I hear from them. And really, you just can ask them questions as to, well, why do you think that way? Why do you think it ought to work that way? And a lot of times you're thinking to yourself, well, let's just see what the next person says. And you know, as you work your way around to see whether, you know, it's something that's like a little bit odd or whether you can kind of like miss the boat on what the issue is. And so, yeah, I mean, sometimes the eyebrows go up, but everybody's had a chance to give their input. And the second opinion conference is one where if you have substantive changes, typically it's going to be a bit of a surprise because the way we operate now is when I circulate my opinion, it's typically going to be at least a week before the opinion conference. And if somebody has a problem, they typically will at least say, you know what, I really have a substantive problem with what you've written, and let me tell you why. And so they're going to typically give you a little bit of a heads up, so it's not so much of the kind of ambush I think they did. I wasn't here back in those days when they did it that way, so I was blessed to have missed that. And I think what happens, honestly, is a lot of times we're going around the table and people agree. If you've got a very complex case with a lot of different issues, sometimes people think, oh yeah, I agree with that, but they didn't agree with the specifics of that. So when you actually put it down on paper, they're like, no, that's not what I meant. And it's kind of like, I said what I said, but I didn't mean it to be what you wrote. And you're saying, aren't they the same? They're like, no, it's not. It's not the same.
Right, it's very different when you put it on paper.
Exactly,
right?
exactly. And that's where the rub comes in at. And that second opinion conference, a lot of times is, you know, a rewrite in order.
So in cases where there's a dissenting opinion, if you were writing the majority, Justice Goodwyn, do you talk to your dissenting colleague through the majority opinion? Do you engage with your dissenting colleague beforehand to try to figure out how each part of the opinion is going to speak to the other part of the opinion? How does that work?
I think it's a matter of personal style. You know, my style is just to pick up the phone and call you. I mean, it's like, what do you I don't understand. What don't you think is right about this opinion? Is there something I can do to massage it? Can we work it out? And a lot of times you talk through it, and every one of my colleagues are, you know, wonderful people to get along with. And at some point you realize perhaps we just disagree. I mean, okay, well, let's find out where the pinch point is, and sometimes you can smooth it over, and sometimes you can't. And if you can, it's like, okay, I understand you're going to write a dissent. And typically the dissent is what I expected, given our discussion that we had as to what they disagreed with in the opinion, which, of course, I think they're wrong. so I don't, you know, agree with what they want to say.
So Justice Mims, when you are on the receiving end of this phone call, you're writing a dissent. What's your approach? How do you engage?
It's done on a case-specific basis because first of all, you have to decide, am I going to write a dissent? There are many times where I may have wanted an opinion to come out differently than it did, but I elect not to write a dissent for any number of reasons. If it's a case where I am dissenting on a particular issue, and there is room for further discussion, then we will have a very substantive discussion about exactly where are you and why are you there and what cases support your view, in order to really to be like iron sharpening iron. And the dissent actually can make the majority opinion better. There are other times when one justice has very strong feelings and elects to write a dissent and is out there by themselves, and the other 6 justices respect the fact that there are such strong feelings. But it's pretty clear early on that there really is not room for further discussion, because it's you're seeing the world through different lenses, and there the majority opinion will often sub silento address the dissent, but rarely will it address it in an overt fashion. The one point that was made that I think really needs to be underscored is that we have a lot of respect for each other individually. We have a lot of respect for each other intellectually and jurisprudentially. And so we are able to dissent or concur without it appearing that that there is that a war has broken out in the conference room and that it's spilled over onto the printed page. Not every court has that level of trust and respect.
So you said something just now that I found very interesting. If I understood you correctly, that you don't always, in a majority opinion, feel as if you need to respond to the dissent, if I understood you correctly. And I'm curious about that. Why wouldn't that be the case?
It's pretty rare that you will see one of our opinions specifically say, the dissent has said this and here is why the court disagrees. We tend to address it in a more subtle fashion. Your analysis has been sharpened and has been changed, and you are answering one or more of the charges of the dissent, but without specifically saying so. I like that that particular rhetorical style, because it gets away from any hint at being personal. I don't think that it behooves a court to be going back and forth with the majority opinion said this, the dissent said that. No, the majority opinion said this and the dissent said that. That doesn't help the development of the law.
Justice Powell, maybe I could ask you to comment on this as well. So what do you see as sort of the value or the role of a dissenting opinion? And do you think there's more freedom for the justice who's authoring a dissenting opinion? Do you feel like the dissenting opinion should respond maybe more directly to the majority opinion? How do you approach that?
I think the dissenting opinion often will respond more directly to the majority opinion. You don't see that working in the reverse. And I think that's more a culture of the court and to some extent that degree of respect for the majority opinion. But you will often see the dissent responding, I think, to certain aspects of the majority opinion. And I think most often that's when the dissenter really has a strongly held belief that there is something analytically wrong with the majority opinion, and we want to get that view out there. I think sometimes it might, if I'm the dissenting writer, it may be writing for the development of the law. This is where the law is now, not necessarily telegraphing where it should go, but perhaps some instances of, yes, this is where we are, but perhaps this is where we should be. Personally, I sometimes will write for the benefit of the litigants who've brought their case all the way to this court, for that circuit court judge who had a differing view. If I feel strongly enough about their position, then I will write to not necessarily vindicate their position, but at least to say, you were heard. I think that comes from the fact that as a circuit court judge, I had a 7-0 reversal, and I thought certainly somebody on the court saw it my way. So a little nod to the circuit court judges out there that you weren't totally off in left field all by yourself. But I have to feel fairly strongly about it. I'm not just going to do that to appease the circuit court judge.
But you do need, it raises a wonderful point, you do need, when you're writing an opinion, whether it's dissenting or majority, to speak to a variety of audiences. You're speaking, as you said, to the litigants in the case, you're speaking to counsel, you're speaking to the lower court judge in a particular case on appeal, you're speaking to future trial court judges who are going to have to interpret. Maybe in a dissent you're helping to shape the law or suggest the direction of the law. So how do you address all of those audiences in one piece of writing? Do you have to choose which audience you're going to emphasize? Do you try to address all of those audiences?
I think I'm more addressing the issue, and the issue will then speak to the audience. I'm addressing the issue with which I disagree, not necessarily targeting an audience so much as targeting an issue.
Justice Lemons, can you speak about this from the side of the majority opinion? Because the same issues are there as well, that opinion is going to be read by a variety of different audiences and has to speak to all of those audiences. So how do you try to address that?
Well, let me start by making the observation that in Virginia, there's one group audience that should not be addressed, and that is some idea that we have constituents. Now, in states where judges are popularly elected, they have constituents, and you can see a stark difference in opinion writing in those states, because when they write opinions, they're often appealing to a constituent base that may or may not return them to the bench. We don't have that in Virginia, and I'm very grateful that we do not, because as Justice Powell says, without that, you can simply focus on the issues. In some of these other states where there's an election around the corner, I am quite sure, and I know for a fact because I've talked to them about it, that the way an opinion is drafted may very well have a whole lot to do with how quickly the ballot box is going to be opened. We don't have that problem. And so that's one group of people that we don't speak to. As far as the others, in many respects, we go back to whether this is a law correction, an error correction, or a law development case. If it's an error correction case, you're speaking to the parties, the trial judge or the intermediate court below, and you pretty much are limited to those audiences because there's not a bigger audience. In the law development cases, you may very well be speaking to future justices on this court. You may be speaking to the Court of Appeals. You may be speaking to the legislature. Take a look at this. Perhaps you ought to weigh in. So there are different audiences, but I do think it varies case by case.
So do you adjust your writing style depending on the audience you intend to address? Do you adjust your writing style depending on the type of case it is, or do you feel like you have a pretty consistent style?
Well, style is the word that I find interesting there. I think in terms of organization and things of that nature, most of our opinions look pretty much alike as far as organization is concerned. We've developed this not by some sort of agreed upon form, it's just been habit. We bring on the case and we summarize arguments and then we knock off the issues one after the other. I think Justice Mims has said it well. Our style has not been to be personally confrontative. And I think that style has carried over in many ways to other audiences. We're not confrontative with the Court of Appeals. We address issues. We're not confrontative with trial courts. We address issues. So if you talk about style, I think the style that we have is a style that has been very well described by my colleagues. We address the issues. It's not personal. And we decide cases in two categories, error correcting and law development, and you ought to be able to tell by looking at an opinion which category it's in.
Justice Millette, what do you think about that? Do you have, I mean, could someone look at a Justice Millette opinion and know that it was yours without your name on it?
I think so, probably.
Why, how so?
I try to be as clear as I can, and I think the primary audience that I'm writing for are the trial judges and the trial lawyers. And I remember from my time in both of those roles that you really don't have the time to look for nuances in a particular opinion. You really want to know what you're supposed to do when you have this kind of issue come before you. And I think that a style that makes it as clear as possible for the trial judges and trial lawyers is the best style to use, and that's what I try to do. And I think by doing that, hopefully the litigants in a particular case also understand where I'm coming from.
And so would you say that's the hallmark of your style? So what is it
I
about
hope
your
so.
style that you said you think
if
somebody could recognize an opinion as yours?
If it's simple enough to understand, for me to understand, then it's probably a good opinion.
Okay.
There is an opinion out there, and I will not identify it, that was written by Justice Millette, but it was handed down by me. And I suggest that you'd have a hard time figuring out that he was the author.
Justice Goodwyn, what do you think? Is there a Justice Goodwyn style?
I don't think so. I like to think of my style as Spartan, sparse. It's kind of like the Dragnet style, you know, Joe Friday.
Just the facts?
Yep, just tell it the way it is. Not a whole lot of flash. Just answer the question, which I think is kind of similar to what Lee was saying about the way he writes. I mean, I'm just trying to have something that's accessible, honestly, to everyone. I would hope one could pick it up, follow the logic in it, and see what the answer is.
So,
You can always tell my opinion if my name was never on it.
how so?
Because in the first paragraph, I give the litigants the answer.
So you don't bury the lead, it's right up front.
Now, in the first paragraph, which I usually write last, I try to, in as few words as possible, state what the at least primary issue or all the issues are, whatever, and say, and for these reasons, we're going to affirm, reverse, whatever it is, so that they can, in the first paragraph, know the bottom line without turning to the last page. And I think I'm the only person who does that, so that's a dead giveaway for me.
So the opinion issues, Chief Justice, have there been times where you would look back on an opinion that you've authored for the court and wish you'd phrased something differently?
Oh, absolutely. It happens when you see how either attorneys or a trial court has taken the opinion and interpreted it. And based upon the language that you use, perhaps they are interpreting in a way that you know was not what you intended. And so you think, wow, I could have said that more clearly. And it's not unusual at all to stop at the end of the day and realize you've spent an entire day trying to get one sentence or one paragraph the way you want it to make it clear. So yes, there are times when you've used words, had sentences that you regret they come back to haunt you.
Does that influence how you approach the task going forward, or that's simply part of the game and it's going to happen every once in a while regardless?
I mean, it's part of the job we have, but I think because of that potential, at least it causes me to try to write as narrowly as possible and to not leave a lot of room for interpretation that may be not accurate because of language that I've used or said too much. So I think I try to write narrowly.
Does that ever enter your decision-making process when a party files a petition for rehearing?
Because I've written it narrowly?
Because the petition might cause you to look at the language that was used in the first opinion and think about its implications that hadn't.
That has happened,
occurred.
and there have been a few occasions I can recall in the past 17 years where someone might raise something in a petition for rehearing, and you look at the opinion and go, oops. And we've actually, not actually granted the petition for rehearing, but we've withdrawn the opinion and taken out a footnote. I remember an opinion where I took a footnote out because the petition for rehearing was like, oh yeah, I should not have included that, and I took it out. So that happens, sure.
Justice Millette, does that enter your thought process as well on occasion?
I think it's sort of the law of unintended consequences. Sometimes, your opinion will come out and people will interpret it differently than you thought. And to me, one of the best ways of avoiding that is the wisdom and experience of my colleagues, to be quite frank with you. A lot of judging has to do with experience. And so when we have people that have had more experience on the bench and they say, well, you know, we had this come up 7 or 8 years ago, and in that case we said this, and you're saying this in this particular case, might cause a concern. And it really helps a lot, and it makes you feel a lot more confident about your opinion when you've had that feedback from your colleagues that you really might want to tweak that and make that a little more clear.
I suppose it also requires a certain level of humility not to be too wedded to your own first draft, I guess.
Yes, I think it's probably true, and I think all of us are pretty much like that. At least I hope we are, because it's not the writing that's so hard; it's the rewriting, right?
Exactly right. Exactly right.
There's a question that you'd hear at our table often, and it comes from each one of us to each one of us, and the question is that necessary to this opinion? Because that's the sort of thing that makes a minimalist out of you. Because you have the experience over time is, I wish I hadn't said that, and more importantly, it wasn't even necessary to the opinion. And after a while, we start asking each other those kinds of questions.
That seems one of the benefits, Chief Justice, of the more modern approach that you've described of more collaboration. It's more likely to catch those, I would think, catch those instances, whereas previously maybe those made their way to the final opinion without too much vetting.